Good evening everyone, my name is Samantha Alonzo and I will be discussing the Section 5 and Section 6 of the Corporation Code of the Philippines. So first, Section 5. Corporators and incorporators, stockholders and members. Corporators are those who compose a corporation, whether as stockholders or members. Incorporators are those stockholders or members mentioned in the Articles of Incorporation as originally forming and composing the corporation and who are signatories thereof. Corporators in a stock corporation are called stockholders or shareholders. Corporators in a non-stock corporation are called members. So there are four classes of person composing a corporation, which are the corporators, incorporators, stockholders, and members. So first, corporators. Those who compose of the corporation, whether stockholders and members. So corporators are the members of a corporation. They are entitled to enjoy all the benefits and rights which belong to any other members of corporation. They became a corporator after the filing or the registration of the Articles of Incorporation. And katulad na rin sinabi kanina sa Section 5, corporators in a stock corporation are called stockholders or shareholders, and incorporators in a non-stock corporation are called members. So basically, they are the members of a corporation. Next is the incorporators. Those corporators mentioned in the Articles of Incorporation as originally forming and composing the corporation and whose executed and signed the Articles of Incorporation and acknowledged the same before the notary public. So incorporators, they are the person who originally formed the corporation and whose names appear in the Articles of Incorporation. So basically, they are the founder of the corporation. Sila yung mismong nagtatag ng corporation. There must be natural persons as distinguished from artificial persons. So only natural persons can be incorporators and hindi pwede yung corporation mismo yung magbuo ng isa pang korporasyon. So at least composed of 2 or more natural persons and not to exceed 15 incorporators. So they are the persons who are in charge of setting up a corporation and registering it with the Securities and Exchange Commission. They are also responsible for filing the paperwork and signing the Articles of Incorporation. They are the actual owners of the business. Although they begin as incorporator with very little rights, they became the owners of the corporation once its existence. So literally, a business is not fully incorporated and legally registered without an incorporator. Kasi syempre, paano matatatag yung isang corporation kung walang magtatatag nito? And yung principal function kasi ng incorporator is to incorporate the corporation and to enable it to become a body politic and corporate under the law. So yung incorporation pala, it is the process of bringing a new legal entity into existence. So incorporation yung process and the end result would be the corporation. And yung kanina na sinabi ko na only natural persons can be incorporators, it is because the incorporator can guarantee na yung mga nakasulat or yung mga nakasaad sa Articles of Incorporation ay pawang totoo lamang kasi they will be liable for damages if napatunayan na mali yung mga nakasulat doon. And kasi yung magiging effect kapag isang artificial person or yung isang corporation din yung nagtatag ng isang corporation, if it is allowed, that corporation would only be limitedly liable in case of falsity. So the authenticity in the Articles of Incorporation may not be assured of, and it is more complicated or complex for a corporation yet to be formed to be organized with an incorporator who is a corporation in and by itself. And it is also said here that all incorporators are corporators, but a corporator is not necessarily an incorporator. Next is the stockholders. The owners of shares of stocks in a stock corporation, they are the owners of the corporation. They are also called shareholders. So, sa stockholders, at the age of 16, pwede ka na maging stockholders, unlike sa pagiging isang incorporator na kailangan legal age, which is 18. So, this is someone who has shares in a company or own a piece in that company. They become a member once their name is entered on the register of members. And according to Section 10, stockholders may be natural persons or artificial persons. Lastly, members, the corporators of a corporation which has no capital stock. So, corporator sa isang non-stock corporation, one of the company's owners whose name has entered on the register of members. So, 'di ba kanina sa isang stock corporation, very important yung profits kasi ayun yung i-distribute sa mga shareholders and stockholders. Depende na lang kung ano yung mga stock na meron sila. It can be common stock or preferred stock. Unlike dito sa isang non-stock corporation na pwedeng charity or for education, so yung mga profits is for the organization itself. And dito rin is may dating rule. Members include corporators of a stock corporation who do not own capital stock. In other words, a stock corporation may be composed of stockholders and members. It was not required that an incorporator be a subscriber for stock as long as minimum capital requirements are complied with. Pero tinanggal din na tong rule na to. So wala na yung rule na to. So ayan yung main components of a corporation. But there are three other classes of persons who play important roles in the formation and organization of a corporation, namely promoters, subscribers, and underwriter. Promoter is someone who has been connected with the business from the start. He can also be referred as the starter of a business or the founder. He is responsible for raising capital from various sources and entering into first agreements for the start of a business and incorporation of a company. So in short, they promote the corporation, they will find subscriber or incorporators, and they will sell shares to them. Next is subscribers, persons who have agreed to take and pay for original and issued shares of a corporation form or to be formed. So they are the persons who have agreed to take original and issue shares pero hindi pa nila kayang bayaran that time. So babayaran pa nila yon at a later date, and they will become a shareholder once na nabayaran na nila and once na na-subscribe yung shares nila ay na-accept na ng corporation. And lastly, underwriter, a person, usually an investment banker, who has agreed alone or with others to buy at stated terms an entire issue of a securities or a substantial part thereof. So, in short, they are the person who undertake to dispose of the shares to the general public. They will exert their best effort to market all or yung part lang ng mga unissued shares which they offered for sale or yung mga binili lang nila from a controlling stockholders. So that's all that the Section 5, the components of a corporation. Section 6. So mahaba yung napapaloob sa Section 6 pero matatakal naman yan later. So first, doctrine of equality of shares. The law provides that except as otherwise provided by the Articles of Incorporation and stated in the Certificate of Stock, each share shall be in all respects equal to every other share. So sinasabi lang dito na kung walang specification na binigay yung Articles of Incorporation, then it is presumed or it is assumed that all the shares are equal. So they have the same privileges and liabilities. It holds that where the Articles of Incorporation do not provide for any distinction of the shares of stock, all shares issued by the corporation are presumed to be equal and enjoy the same rights and privileges and also subject to the same liabilities. But, syempre importante yung share sa isang stock corporation. So, it is very unlikely to happen since nilalagyan ng specifications ng kung anong rights meron ang shares na nakaklasify within the corporation. Pero sinabi nga dito na kung walang distinction or specification, then all shares are equal. Next, who may classify shares? Classification of shares may be made by incorporators, board of directors, and the stockholders. So first, incorporators. The classes and number of shares which a corporation shall issue are first determined by the incorporators as stated in the Articles of Incorporation filed with the Securities and Exchange Commission. So, classification of shares may be made at the formation of the corporation by the incorporators. So, kung ano yung napag-usapan or kung ano lang yung napag-agreehan nila, yun ay classification of shares. And after the incorporation of the corporation, pwede pang ma-reclassify yung mga shares. Pwedeng palitan or pwedeng baguhin ng board of directors or stockholders yung mga nasa Articles of Incorporation by a majority vote of the board of directors and the vote or written assent ng stockholders representing at least 2/3 of the outstanding capital stock. But if yung mga changes na naganap or yung mga nabago nila is nalimitahan nila yung mga rights ng class of shares or authorizes preferences in any respect superior to those of outstanding shares of any class, yung mga shareholders na matatapakan or yung magkakaroon sa kanila ng malaking impact yung changes, then pwede silang maging dissenting stockholder wherein magwi-withdraw na lang siya sa corporation and demand payment of the fair value of his shares kasi nga malaki yung effect sa kanya ng pagre-reclassify ng shares kaya alis na lang siya sa corporation. What are voting shares? So, voting share, ito yung share with the right to vote. It is generally customary to give the right to vote to the common stock and to withhold it from the preferred. So, generally, common stock yung may mga voting rights. Only shares classified and issued as preferred or redeemable may be deprived of voting rights. Under the code, whenever a vote is necessary to approve a particular corporate act, such vote refers only to stocks with voting rights except in certain cases when even non-voting shares may also vote. So, common stock lang yung may voting rights pero there are some instances na kung saan yung preferred shares or redeemable shares may also vote. So, mamaya matatakal yung kung saan or kung kailan lang sila pwedeng bumoto. And lastly, the rule is not one stockholder, one vote, but one share, one vote, because representation in a corporation is commensurate to extent of ownership. So, kung ilan yung pagmamayari mong stocks, then ayun yung extent ng iyong ownership. Because if it is per head or if it is one stockholder, one vote, it would be unfair doon sa may malalaki or may mataas na shares. Halimbawa is, I own 500 shares and you own 2 shares tapos siya 10 shares. So, kung one stockholder, one vote, ang unfair nun sa akin kasi mas malaki yung shares na ininvest ko. Dapat, kung gaano kalaki ininvest mo sa corporation, yun din dapat kalaki yung say mo dun sa corporation na yun. Kaya, hindi siya one stockholder, one vote, or one head, one vote, but rather, it is one share, one vote. The right to vote in a stock corporation. So, ang karapatang bumoto ay likas na kakayahan ng isang shareholder. It is settled that unissued stocks may not be voted or considered in determining whether a quorum is present in a stockholders meeting. Only stock actually issued and outstanding may be voted. So, common stock has one vote per share. Each share of stock is entitled to vote unless otherwise provided in the Articles of Incorporation. So, Articles of Incorporation may authorize different classes of shares with different voting rights. So, they have the right to vote on matters regarding corporations such as the election of board of directors, issuing of new securities, acquisition of assets, approving dividends, or changing something in the operation of the corporation. So, they can vote in person or by proxy. So, if it is in person, only shareholders of record are eligible for voting in the meeting. They will tell you if you are owner of standing shares and if nandun ka sa kanilang record. And if wala, then you do not have the right to vote in the meeting. Corporate bylaws typically require a quorum for voting at a shareholder meeting. So, quorum, it is the minimum number of stockholders or members required to be in attendance in order for them to be able to take official action. So, kung hindi ma-meet ang quorum, hindi sila pwedeng mag-start kasi they do not have enough authority to allow binding action to be conducted. So, ang shareholders may also assign someone to attend to company's annual meeting or emergency meeting. It is either may ginagawa siya or ayaw nilang umattend. So, it is by proxy. So, before the meeting, 30 to 40 days before the annual shareholders meeting, the shareholder will receive a package of proxy materials that contain the things that will be needed in the meeting. So, it contains documents of the annual report, proxy statement, and proxy card or voter instruction form for the upcoming annual shareholder meeting. So, proxy votes may be cast by mail, phone, or online before a cut-off, and typically it is 24 hours. Their response may be against, abstain, and not voted. So again, if it is by proxy, it should be writing, signed, and filed by the stockholder or member in any form authorized in the bylaws and received by the corporate secretary within a reasonable time before the scheduled meeting. So proxy acts as the representative of the stockholder, but they do not have the right to participate in the management. So for example, in the right to vote in a stock corporation, so A, B, and C own Class B shares while D, E, and F own Class A shares in the Shimi Corporation. So, naka-indicate sa kanilang Article 7 of Articles of Incorporation approved by the Securities and Exchange Commission was only holders of Class A shares have the right to vote and the right to be elected as directors or as corporate officers. So, si D, si E, and si F lang have the right to vote and be elected. Pero after 5 years, binago nila. Article 7 was amended. So, ito na. It is stated that except when otherwise provided by law, only holders of Class A shares have the right to vote and the right to be elected as directors or as corporate officers. So, dito, may exception na. So, in December 22, they held their annual stockholders meeting and election of directors. So, during the meeting, D owns Class A shares. Dineclare niya na si A, si B, and si C who own Class B shares was not qualified to vote or even to run as a director. Pero dati naman they can vote and they even got nominated. Pero si D still announced that candidates holding Class A shares were the winners of all seats in the corporate board. So because of that, si A, si B, and si C nagprotest sila and they claim that they are being deprived of their right to vote and run and in violation of their Article 7. So the question is that acceptable that A, B, and C were deprived of their right to vote and be voted for as directors in Shimi Corporation? So the answer is no, it is not acceptable na na-deprive sila because their amended Article 7 except when otherwise provided by law. And according to Section 6 of Corporation Code of the Philippines, no share may be deprived of voting rights except those classified and issued as preferred or redeemable shares unless otherwise provided by the code. Pero wala namang nakasulat sa Articles of Incorporation nila or even dun sa problem na Class B shares ay preferred shares or redeemable shares. Kaya ina-assume natin na yung shares nila ay merong voting rights. Thus, mali ang ginawa ni D na hindi niya binigyan ng karapatang bumoto or maboto sila A, si B, and si C. The right to vote in a non-stock corporation. The right of the members of any class or classes to vote may be limited, broadened, or denied to the extent specified in the Articles of Incorporation or the bylaws. Unless so limited, broadened, or denied, each member regardless of class shall be entitled to one vote. So, ang karapatang bumoto sa non-stock corporation ay nakadepende sa kung ano nakasulat sa Articles of Incorporation. So, kapag sinabing hindi pwedeng bumoto tong class na to, yung ganito, so, hindi sila pwedeng bumoto. But if it doesn't have any stipulation about that, each member regardless of class shall be entitled to one vote. So, in non-stock corporation, the voting rights attached to membership, members vote as persons in accordance with the law and the bylaws of the corporation. Each member shall be entitled to one vote unless so limited. So, katulad na rin ang sinabi kanina. So, meron din silang quorum, which is yung minimum number nga na members na kailangan doon sa meeting. So, quorum shall consist majority of their members. So, the number of trustees shall be fixed in the Articles of Incorporation or bylaws. It should be minimum of 5 and not be more than 15. So, only member of the corporation shall be elected as trustees. The corporation at all times should keep a list of its members and proxies. So, like in stock corporation, they can vote through proxies then. So, the list shall be updated para malaman kung ilan or sinong members and proxies ang a-attend sa scheduled election. So, dapat ma-update 20 days prior to the meeting. So, they can also hold regular or special meeting outside their corporation, so outside ng location ng kanilang corporation, provided that there is proper notice sent to all members that indicate the date, the time, and place as long as it is not outside the Philippines. What are non-voting shares? So, non-voting share, ito naman yung share without right to vote. If stock is originally issued as voting stock, it may not thereafter be deprived of the right to vote without the consent of the holder. So, hindi siya pwedeng tanggalan ng voting rights without the consent of the holder. And kapag hindi nagkaagrihan, yung shareholder may be considered as dissenting stockholder wherein he can demand the payment of the par value of his shares and aalis na lang siya sa corporation. Kasi malaki yung effect sa kanya ng pagtanggal ng rights sa kanyang shares. Under the code, no share may be deprived of voting rights except those classified and issued as preferred or redeemable shares. So, sinasabi lang dito na lahat ng shares ay may right to vote pwera lang sa preferred or redeemable shares unless otherwise provided in the code. And note that the enumeration section 6 hindi in-include doon yung election of directors and trustee as one on which the non-voting shares may vote. Kasi may mga instances na kung saan pwedeng bumoto ang preferred shares or redeemable shares. Pero hindi kasama doon yung pagboto sa directors and trustees. When non-voting shares are provided for, the code requires that there shall always be a class or series of shares which have complete voting rights. So there are two main classes of stocks, common stock and preferred stock. Common share of stock is one which entitles the holder thereof to a pro rata division of the profits, which means proportional and not equal, so it should be based on their ownership, if there are any, and its assets upon dissolution, without any preference or advantage in that respect over other stockholders or share of stockholders, but equally with all other stockholders except preferred stockholders. So, common stock, tinatawag siyang common stock because it is the basic class of stock na ini-issue ng mga private corporation. Kasi diba yung requirement ay at least one class of share with voting rights. So, it is common stock. And they don't hold any extraordinary rights or privileges unlike preferred stocks. Common shares have complete voting rights. Hindi sila pwedeng mawalan ng rights except as provided by law. Common stockholders are the residual owners of the corporation. Residual only because makakakuha lang sila ng assets in case of liquidation ng business if nabayaran na lahat. So, sa kanila yung mga natira. And the simplest corporate structure has only one kind of stock, which is common or ordinary stock. A corporation may issue more than one class of common stock, being designated as Class A, Class B, and etc. Next is preferred stock. Preferred share of stock is one with a stated par value which entitles the holder thereof to certain preferences over the holders of common stock. So, preferred, which means favorite or sila yung inuuna. May advantage sila sa dividends, sa assets in case of dissolution of the corporation, and other preferences na nakastate sa Articles of Incorporation na hindi nagva-violate or hindi lumalabag sa Corporation Code. And as already stated, each share shall be in all respects equal to every other share, except as otherwise provided in Articles of Incorporation and stated in Certificate of Stock. So, sinasabi lang dito is about the Doctrine of Equality of Shares. Certificate of Stock, it is a written acknowledgement by the corporation of the interest, right, and participation of a person in the management, profits, and assets of a corporation. And about naman sa voting rights ng preferred stock, bihira lang sila mabigyan ng rights to vote. There are only some instances or matters na pwede silang bumoto. And more than one class of preferred stock may be issued, usually designated like first preferred, second preferred, and etc. So, common stock and preferred stock. Both type of stock, common and preferred shares, represent a piece of ownership in a company, and they are tools that stockholders can use to try to profit from the future successes of the corporation. So, the common stock, they are entitled to have the voting rights. So, mas may karapatan sila or mas may say sila about sa management ng corporation. Be it election of the directors, so may mas opinion sila. So, one share, one vote. And then sa preferred stock, they take a multiplicity of forms. So, the most common form can be classified as to dividends and as to assets. So, as to dividends, this is the distribution of income. So, mas inuuna silang bigyan ng dividends kesa sa may mga common stock. And as to assets, so upon liquidation, so it means magsasara na yung business. So, unang didistributan ng assets ay yung mga creditors, and then bondholders, and then shareholders, and ang uunahin ay yung may preferred shares. So, di ba? Asset equals liabilities plus capital. So, mas unang bibigyan is yung liabilities, so yung mga creditors, and then capital, so mas uunahin yung preferred stockholders kaysa sa mga common stockholders. So, hindi sila masyadong binibigyan ng voting rights. Wala sila halos karapatan sa management, pero may ilang instances na pwede silang bumoto. So, sila yung unang-unang bigyan ng assets or ng dividends, pero fix yung amount. So, for example, yung net income ng business is 100,000, And then, ang preferred shares is makakatanggap ng 80,000. So, fixed na yung amount nun. Though, they have 10 preferred stockholders. So, 100,000 minus 80,000 is equal to 20,000. So, yung 20,000, ayun yung natira. So, it means ayun yung paghati-hatian ng ordinary stockholders. So, ayun yung isang disadvantage ng ordinary shares or common stockholders kasi yung mga natira, ayun na lang yung paghati-hatian nila. But what if yung net income is 1 million and then yung preferred stockholders makakatanggap sila ng fixed amount na 80,000 and then ang magiging amount na paghati-hatian ng ordinary stockholders ay 920,000. Ayun yung maganda kapag lumalago na yung business. If a company does well, the value of a common stockholder can go up. But if a company does poorly, the stock's value will also go down. But nakadepend pa rin yung amount doon sa nakastate sa Articles of Incorporation and yung mga napag-agrihan. Next, what are redeemable shares? Are shares that a company has agreed it will or may redeem at some future date. So, redeemable preference shares are those type of preference shares issued to shareholders that have callable option embedded in which they can be redeemed by the company or the issuer sometime in the future. So, they can be redeemed later by the company at predetermined price. But first, what is redemption? So, according to Section 8 of the Corporation Code, redemption is the repurchase or the reacquisition of stock by a corporation. So, in short, ito ang pagkuha ulit ng corporation or ng issuer ng shares sa kanyang shareholder. So, the company redeems shares when it decides to pay back the shareholder, be it in cash or property. But remember, first, a company cannot issue irredeemable preference shares. Next, a company may issue redeemable preference shares for a period of 5, 10, 15 years, but a company cannot issue redeemable preference shares for a period exceeding 20 years. And lastly, the issuer shall assure that the redeemable preference shares are paid off in full because shares cannot be redeemed unless they are fully paid up. So, hindi pwedeng kalahati lang, dapat buo. And make sure that the conditions specified at the time of issuance are fulfilled. So, this will be also discussed again by the other reporters. Lastly, instances when holders of non-voting shares are allowed to vote. So, kung ang common shareholders, they have the right to vote on every matter sa corporation, ang preferred shareholder naman, they only have the right to vote on certain matters which directly affect the rights attached to its preference shares. So, holders of non-voting shares shall nevertheless be entitled to vote on the following matters, like amendment of the Articles of Incorporation, adoption and amendment of bylaws, sale, lease, exchange, mortgage, pledge, or other disposition of all or substantially all of the corporate property, incurring, creating, or increasing bonded indebtedness, increase or decrease of authorized capital stock, merger or consolidation of the corporation with another corporation or other corporations, investment of corporate funds in another corporation or business in accordance with this code, and lastly, dissolution of the corporation. However, there is an exception under Section 47 of the 2013 Act wherein yung preference shareholder na hindi pa nakakatanggap ng any dividend by the corporation for 2 years or more, the preference shareholders would have the right to vote on every matter in the corporation just like the common shareholders. And note that yung mga shares na naklasify as voting and non-voting shares are entitled to vote in the 8 instances that I mentioned earlier. That's all. Thank you.